office bearers of MCHI CREDAI, Parimal Bhai, immediate past presidents of CREDAI, office bearers of Naredco and Pieta, and friends. As I stand here, I'm remembering the air hostess announcing in the flight of the safety precautions. And everybody says, why do you want to listen? We have listened it for three flights now. We have listened it for 3 hours. And why this man is again standing here and giving the same instructions? It's in your interest to hear it again and again till we all get used to that instructions, or we get used to the act which is going to come and help us. It's very important that this is the same piece of legislation where all speakers are going to speak. It's the same piece of rules and regulations where everybody is going to speak on. So there are bound to be repetitions, but practice makes man perfect. So it's important that everybody listens to again and again what has been said, because this is the first time that we are entering into this area of RERA regime. Since it is for the first time that we are entering into the RERA regime, it's important that we pay attention to it in depth, understand every facet of it, understand every rule of it. It's like reciting Gita every day. And when you recite Gita every day, you find new issues every day you read the Gita. You recite Quran every day. So work with it. So please understand that this is reality. Let's use this act something as a tool where we will now be able to grow in a systematic and a corporate manner. This is an opportunity which is being offered to us by this act to become more systematic, not to take projects, not to sell the material, not to commit things which you can't commit, which you can't deliver. So this is an act which actually will help us to grow our business multifaceted in a more systematic and process-driven manner. So let's take this as an opportunity, because now this is, if somebody from our organization would have said that let's do that, we might have avoided it. We have been doing for 60 years. We have grown so many times. By doing this again and again, why you want everything to change? So we would not have accepted it, and we would have remained Lala companies for ages. This is the time to convert ourselves from Lala companies to professional organization, and the act fastens this on us. This is a compulsion which we have, and we must use this as an opportunity to grow from where we are today in a more systematic manner, so that we have more time to play golf, cricket, or whatever we want to do as an owners. And our staff also has more time to take leave, because we'll be running the business in a more professional manner because of the provisions which this act has. I will be going through this act. And one more thing, last time I am repeating, most of the definitions and coverages which are given in acts, rules and regulations are very wide. Don't waste your time to find a way out of it. Just don't waste your time. Just concentrate on how to work with it. It will be much easier and better to do that way. So think positive. Don't think negative. Just don't think this as an impediment. Don't think this as a onerous duty cast on you. Think it as a tool which will help you to improve your business processes and compliances and transparency, which will ultimately benefit, because your consumer will get more attracted to you because you will be more transparent about it. My flow of the whole thing is that I will start with what as a promoter. My entire flow is that what as a promoter I have to do right from the day one till I give possession. So what are the various steps which I have to take, how I have to do it, and what are the precautions I have to take it. Understand, these are the initial observations from the first stage of reading of these acts and rules and regulations. But these are the various areas which we have covered. So any person, and mind well, don't think that I will be an investor in a project, so I will not become a promoter, or I will be a joint developer, I will be a landlord, so I will not be a promoter, so I will not be covered with the liability. any person who intends to sell the flat in under construction project is a promoter. It's a very wide definition, it's all inclusive definition. So let's not work around it, let's work with it again, as I said. Any project where you develop a building or a development of land in the plots is a project. So anything where you construct a building, wing of a building or whatever it is a project. So, and any sale which you do in that is any person who does that is a promoter. Then phase of a project, and mind well, this is the most important term which you must understand and grasp it thoroughly. And you must know that the phase of a project is what you define. You yourself define what is the phase of each phase of your project. And you be careful about the phase of the project, because as you will go from here on, you will realize that phase of the project is exceptionally important. If you have decided wrong quantity or quantum of the phase of a project to start with, you will end up into a problem, whether it is too small, whether it is too large. But a phase of the project is the fulcrum on which the whole RERA Act revolves. So the two important points which are very important is phase of the project and a date of completion. If you are able to know these two areas very well, and if you understand that if you are not going to protect yourself under these two headings, then you are ending into a big liabilities. So it is very important that we define the phase of the project very well, well understood how it can be delivered, how it can be done, and also next issue, which is the date of possession, which we are going to write. I will explain it later on as it flows starts. Before you start sales, so registration is very important. All ongoing projects as on 1st May 2017, where occupation certificate or building completion certificate is not received on 1st May 2017, will require to be registered before 31st July 2017. Let's not ask question, I've constructed 40 years back, 70 years back, 60 years back, today, yesterday, whatever it is. Any project which has commenced before 1st May 2017 has not obtained OC or BCC before 31st May 2017 needs to be registered before 31st July 2017 if we want to sell any product out of that under construction. If it is after construction, but if you have a customer, you have already sold, and there is a customer in place under MOFA regime, and a project is to be, then the project has to be registered, even if you don't intend to sell any of the flat beyond today. So that means an ongoing project, suppose you have constructed 30 floors, you're about to get occupation certificate or whatever it is, and you have sold 90% of the flat and you don't intend to sell 10% of the flat before you get occupation certificate. But since you have already sold 90% of the flat, there is even one single buyer in that project, you need to be registered before 31st July 2017. This is very clear. So every project where there is a buyer and which has commenced construction before 1st May and completion has to be registered before 31st July 2017. Now, in the registration process, like Aarti pointed out, and I'm not going into the fields, but what you are supposed to do in those fields, but she has shown the fields, but what we are supposed to be doing within those fields is what for us to understand. So, first, let us understand there is a disclosure of promoters. Disclosure about the promoter. So, promoter disclosure is basically brief detail of enterprise, the particular of registration, the name and photographs of the promoter, authenticated copy of PAN card, photograph contact details of the promoters, if he's individuals, partners, directors, everything, and a brief details of the project launched in last 5 years and whatever he has done with those projects, delays in those projects and the reasons for delays in those projects. This is about the promoters. So this is an information which is general, which has to be fed in all your projects which you are going to feed. Suppose you have 10 projects or 15 projects, you have to ensure that this detail is constant in all projects if that is being implemented by the same company. So you can't have varied information under this clause for the same company if it is for 20 projects. So you have to be very careful. You can have 20 sister concerns, but then promoters, the name of the promoters and all those details has to be constant. You can't have varied information there. So this is a master file for the details of the promoters for each of the project, whoever is the promoter, JVs, JDs or whatever it is. It is to be completely, those informations have to be given. Now next step is details about the project, disclosure about the project. The first thing is, of course, the location of the project, including latitude and longitude of the plot boundary. So this is something different which has been now introduced, which is including latitude, longitude and latitude of the project boundary. Those details of the project has to be fed into the system. Then the copy of the legal title report. Mind well, instead of legal documents to be filed, this is the copy of the legal title report from the professional practicing advocate which you have to file now, and which details complete gives the what is the title reflecting the flow of the title. Means how the promoter who is about to sell the property, how the flow of that promoter, how the title flows to that promoter, how he is entitled to sell this flats to a consumer in the market or the plots to the consumer in the market. So there is a complete legal title report which we have to attach, and which has to be have the flow of the title to the promoter and information regarding encumbrances on that property. And this encumbrances may be physical or may be legal or maybe anything. But all those encumbrances have to be mentioned. So if you have a slums on the property, you have to construct the slum, you are doing it under slum rehab and you have 2,000 huts to be re-established, it's an encumbrance on your title. So that has to be mentioned, that unless you rehabilitate these 2,000 people, this is the encumbrance on the property, or there is a mortgage on the property, you have taken a loan from the bank, or there are some legal dispute with the past owners which you have not yet settled. There are no stays on it. There is no legal stay on it, but there are some disputes which are pending in the court, which though there is no stay, but then even if there is no stay, all these encumbrances details have to be mentioned in truth. Again, I am requesting, please don't try to hide anything. It's very important that anything which is hidden is going to haunt back, because this all information is going to be available to public. And in today's world, there are at least, I think 50% of Indian population has no other business other than looking into websites and finding flaws of your project. And their business is that. And they employ professionals to actually do this. So it is better that you are careful while you are feeding in data, and these are now going to be in a public domain. So it's not going to be between a buyer and a seller. It is not too private. It is nothing personal now. So everything what you do, you please get used to it. That if there might be some cases you have forgotten about it because it was filed 30 years back. Please dig that out and reflect it in your encumbrances. So it is important that this is given. And then authenticated copy of the approvals which you have got to the project till date. This is something which is very important, that we have to have the authenticated copy of approvals and commencement certificate which you have till date. For each of the phase, again I said, project is layout, 70 buildings, 30 buildings, 10 buildings, 5 buildings. Phase of the project is my choice. I might select each wing as a phase of the project. I might select each building as a phase of the project. I might select part of the building as a phase of a project. So it is, choice is mine. The phase of the project is been defined to define, it's completely on my choice, and I will define the phase of the project. Then again, going further, sanction plan, layout plan, specification of the project, and sanction plan means, and please understand what does all that mean. It means building plan, service plan, parking and circulation plan, landscape plan, layout plan, zoning plan, and such other plans, including structural design, if applicable, and all those plans, environment clearance and everything. These are the sanction plan you are supposed to load as per the, so now what is the shift from the business which we have been doing till date? We've been going ahead with the work without complete building plans till date. We've been, अभी तो फाउंडेशन का प्लान दे दे, बाद में देखेंगे ऊपर क्या करना, देखेंगे सोचेंगे क्या, अभी क्या कहा है, बुकिंग चालू करने का है कल से. So all this is now practically going to go away. You will have to be prepared with all plans. And that is what, when I say that there is a complete, let's use this opportunity to improve processes within our organization. What processes we improve within our organization by this? We must learn now that I must able to churn out the plans in 15 to 30 days. I must be able to churn out what I need from the project before I have taken this project. Not that I have bought it, now I am thinking what to do. Meanwhile, board लगा दिया, 4 broker को बुलाया, उसको बोला अभी कल से जरा बेचना चालू कर, 5-6 फ्लैट बेच डाल, so that थोड़ा interest payment ये वो सब हो जावे और कल से काम चालू करेंगे. No, this is gone. You cannot accept even a 1 rupee as an investment in the project unless it's a loan, not as an investment unless the project is registered. Please be aware of that. So the project has to be registered and there is no choice about it. And to register the project, the information which is required to feed in is available here. So it is very important for us to understand that these are the areas where we have to be perfect now. These are the areas where our business process can improve, and we can plan a project and forget about the project. Gone are the days where we go on sitting on that plan again and again and modifying it as the market changes. Because any modification, as I'll later on say, will require a lot of permissions and approvals. So gone are those days. So it is important that we improve our business process, and before we commence the project, we have all the plans in place which we need to put. We need to put all information regarding FSI and TDR which are proposed to be utilized. This is unique to Maharashtra. This was not there in RERA Act. This was not there anywhere else. But we got it, the authority thought fit to include the proposed FSI and TDR which you are going to use on the site is to be as a column which is to be included. Why? So that tomorrow, if you are only putting sanction plan, then anything to be done beyond sanction plan requires consent of the allottees. But if you have put in a proposed plan and where you have disclosed all what you plan to do, so that gone are the days where we could show initially only 5 buildings and 6 buildings and then later on construct 13 buildings out of it. So whatever proposed FSI we intend to use in the project needs to be specified and clarified. That is something which is there as a part of the rules, and we have to give that on the details. Proposed plan, proposed layout plan of the whole project and the floor space index of the whole project. So this is not the project or the phase of the project you are, but also what you are proposing to use in the whole project as a whole, the FSI which you intend to use. You might be wanting to use 4, you might intend to use 5. Don't sell today as showing it as a 2 FSI project and tomorrow make it 4 FSI and try to do it now. That is going to be not possible. Under, of course, MOFA also it is not possible anymore with the various Supreme Court judgments which have come again and again. But still now it is available on a website for a person to challenge you that you have never shown me that you would be constructing 4 FSI or 3 FSI. So it is not there. So please make the true disclosure to consumer, true disclosure on the website, the proposed FSI which you want, proposed plan, proposed layout plan, and the floor space index proposed to be consumed on the whole project. Then comes this proposed FSI is to be given at the time of registration also. Then proposed number of building and the wings which you want to construct. Again, so everything has to be thought of even before you start selling the first building. Everything has to be thought of before you start selling the first building. What are the number of buildings you will construct? What are the number of wings you will construct? What are the number of, what all you are going to propose in the whole thing, and all things have to be uploaded. So it is not only the sanction, but the proposed also has to be uploaded. Then the number and type and the carpet area of the apartments for sale in the project. Now this is restricted to the phase of the project. The phase of the project which you want to register. So the apartment, the carpet area of the apartment for sales, the number and area of the garages, and the covered parking space. The new thing which has been introduced into this is the covered parking space. The parking spaces in podium, basements, and stilts were hitherto till in RERA are considered as a covered parking space which are allowed to be sold. But mind well, in Maharashtra, MOFA is still in place and MOFA has not been repealed. And since MOFA has not been repealed, every parking space is not allowed to be sold. So there is a conflict. The RERA says that covered parking space can be sold and MOFA says covered parking space can't be sold. So whatever is not derogatory to RERA, and covered parking space not to be sold is not derogatory to RERA, so it will be implemented. So covered parking space till MOFA is in place will not be allowed to be sold. So we will have to continue to deal with the parking space as we have been dealing with the parking space till date. Even though we have registered it, we have shown the covered parking space, but hopefully at some point of time, if MOFA can get amended, then the covered parking space will be allowed to be sold under RERA. So this is what is very clear. And then the aggregate area in square meters of the recreation open spaces which we are going to give. So here the escape route is, and that is very important, is not the escape route, but the declaration that in the layout of 10,000 meters, the aggregate open area which I am going to keep is 2,000 meters. That 2,000 meters can't be changed. So that 2,000 square meter which you have declared at the time of registration cannot be reduced to 1999. So if you are going to provide recreation open space, whatever you are going to provide, please disclose that into the registration process. Then particulars in respect of architecture, design standards, type of construction technology, earthquake resistant measures, and common areas and amenities of the layout. All this also has to be completely given in detail at the time of registration of the project. So all these details of architecture and design standards which you are using, BIS, ISI, whatever it is, all those things has to be given. Technology which you are going to slip form, you are going to use normal methods, you are going to use tunnel form work, whatever you are going to use. So all those details, RCC, whatever it is, has to be given. And earthquake resistance. So you will be compliant to scale 3, scale 4, depending upon the geographical location you are there. Then nature of organization of allottees which you are going to do. Gone are the days where I could have written in my agreement that I might form society, I might form company, I might form apartment ownership, I might form any other organization. What is exact type of organization you intend to form of the allottees in this project, phase of the project? So if you want to do apartment ownership, please disclose this as in I will be forming apartment ownership declaration. I want to form a society, please do that. I want to form a company, please do that. But you will have to give the exact detail that what you intend to do with that. Then proposed number of floors in respect of each of the buildings. How many floors you are going to construct? How many are proposed? So suppose my approval today is of up to 11 floors only and I am proposing 20 floors to be done. So I must declare that I am proposing to do 20 floors in this building. All these disclosures are there, so there is no surprises later on for the buyer. So buyer is aware that you have proposed 20 floors. Today you have approval of 11th floor, and the agreement, the model agreement which is attached with the rules, clearly says that I am entitled to take approvals from time to time. So it is not that I must have, whatever I have proposed, I must have an approval of that. I am entitled to take approval from time to time. That my proposed the agreement which is attached with the rules, model agreement which is attached to rules, gives me that opportunity. But I must have disclosed this. So I can't sell a building saying that I will construct only 14 floors and tomorrow I get more FSI. So I will then say, okay, FSI बढ़ गई है, तो अभी 20 माला ठोक देंगे. MOFA also doesn't allow, but then RERA makes it public document, so it won't be allowed. So very simple. Plan of development going to be is all external development work which you propose to do. Firefighting, drinking water facility, emergency evacuation services, renewable energy, all what you plan to do in a layout has to be disclosed. So anything which is not disclosed and done, welcome. But anything which is disclosed and not done, problems. So please ensure that whatever you disclose is minimum. You can't, and I've been telling in my office again and again, please don't show pretty ladies standing next to swimming pool because they might claim that when they come. Start using abstract informations. Please, I mean, don't put in things which you are not going to be providing. I mean, you don't know what people will come out tomorrow with. And start avoiding using goras on your pictures, because that you will never be able to bring them. So please be sure that all the information which you are feeding in is not only on the website which you have fed in, which is going to be held against you. In any form of communication going out of your salesman is going to be held against you. So please ensure that every lowest of the salesmen do not give out information for the purpose of achieving targets which will haunt you for life. You please ensure this, because salesmen, for the purpose, you give them target, they go in the market to fulfill the target and they promise moon. The moment they start promising moon, that person might record it, they might keep the documents of it. Everything will be used against you, because any form of communication is considered now as a part of an agreement under the Act. So whether it is by brochure, whether it is by the advertisement, whether it is by anything, is now considered to be an agreed facility which you are bound to give to that individual. So please ensure that the communication which now goes out from the salesman's DAX is all monitored. Is nothing goes beyond what is approved as a company. Again, process driven. This is how all multinationals work in 180 countries. And that is how they become actually multinationals. Because every process in the organization is defined and is well laid out. Standard operating procedures are well laid out. We'll have to do that in our case, unless it's 1 or 2 building project development where you are sitting 24/7 and you don't need any process. But if you are doing through people, then everything has to be process driven. And everything, standard operating procedures, manuals of how to deal with people, what documents to be given, should be available within your organization. Because the liabilities are tremendous. The proposed number of floors, like I said, has to be there. And as you go on getting the sanction from time to time, you have to upload it. Then next issue is the draft of allotment letter, draft of agreement for sale, draft of the conveyance deed which you are going to finally sign in favor of the legal entity of the allottees has to be also be submitted. This is also now to be put on the website. All the drafts. So you cannot now say कि conveyance तो 10 साल के बाद करना है तो उसका मेरे को conveyance deed आज क्यों draft करने का. Whatever you are going to convey at the end of the period, whatever document you are going to prepare for that, whatever you are going to do has to be on the website. And any changes in that is going to lead to adjudication and compensation. So please careful that whenever you are planning, again, that is why whenever you are now planning a project, you must know what you can convey, what you cannot, what you are proposing, what you are not proposing, what you are going to be finally using this. And like Parimal Bhai said, grandfather built and I am not wanting to convey till date is all gone days. What I built today, I have to know what I am going to convey to my buyers. The name and addresses of the real estate agents, whichever who wants to sell, including housewives or referrals or whatever it is, please make them register it and call them real estate agents. And the names and addresses of the contractor, architects, structural engineers, and other persons concerned with the development of the project. Again, all those has to be finalized. Of course, those names can be changed midway if you want to change a consultant or whatever it is, but you have to reflect this on the website. Proforma now, so from promoter, we came down to project, and now we come down to transaction. So transaction which is going to happen with the buyer. So proforma of allotment letter, like I said earlier also, proforma of allotment letter, agreement for sale and conveyance is to be shown to the buyer. You have to take take a disclosure that all these 3 things have been shown to the buyer. This is very, very essential. It's an information which you have given to the buyer. Agreement for sale shall be in conformity with the provisions and rules and regulation and should be in accordance with Annexure A of the rules. The rules clearly says that the agreement which is attached herewith is a model agreement and can be modified or changed to suit yourself. But the basic clauses which are not contrary to RERA or which are in line with RERA have to be incorporated. That means the payment terms which are mentioned in the model agreement, that you can collect 10% before agreement, you can collect 35%, some 35% before plinth, or some 70%, 65% before, whatever, those percentage which are given in the Annexure A to the rules. Your agreement which you are entering with LOT cannot have higher percentage than that. That means at the plinth, if suppose the model agreement which is annexed to Annexure A shows that you have to collect only 35% up to the plinth, then your agreement cannot show 36%. But within the plinth, you can have bifurcations. Like for the slabs, if 65% has to be paid for all the slabs in the building, then for each slab you can collect 2%. But the aggregate of all the slabs cannot exceed 65% of the money which you will collect when all the slabs of the building which is proposed is completed. So it is very important that you we don't cross, you can draft the agreement as you want, but the crux of the matter, that is the interest to be payable, and all those crux of the matter has to be incorporated in your agreement. So this is something which is very important. Promoter at the time of booking an issuer shall be responsible to make available. Following things are to be made available to the allottee at the time of by act and rules. Sanction plans, layout plans, specifications, all these things have to be the stage-wise time completion for project, including provision for civic infrastructure. Here we have been used to give only the completion dates. We have never given stage-wise completions. But this is now what is required to be given. Stage-wise time schedule of completion of the project, including provision of civic infrastructure like water, sanitary, when you will get water connection, when you will get sanitary connections, when you will get stormwater connection. All these dates have to be written and disclosed. So there is no longer a escape route out of that again. So all these things can happen only if you have planned 100%. Empire State Building was built in 1923 in 14 months. It was planned for 36 months. This is how USA works, and this is how the government wants you to work today. It was built in 14 months, planned for 36 months. So, and that height with the 10 basement or 12 basements, everything was planned before the work commenced. Exactly what they are looking at is that you will plan everything before you actually plunge into and get some allottee to buy into your project. Public money you don't accept unless you get into a complete depth of the project. This is the intention of the act, and we have to follow this intention very thoroughly. Rate of interest to be payable by both the same, whether you claim or you pay. So, and that has to be in line with SBI. So, State Bank of India's prime lending rate plus 2% is what you can claim for the default from allottee, and what you end up paying in the case of a delay in the delivery of the possession. Please understand that the date of possession which you write in the transaction is so important that there is no provision that you will not be required to pay interest on the monies received by you till the date, from the date of completion to the actual date of completion. That means, suppose in the agreement you have mentioned that the date of possession is 31st December 2017. From the 1st January, SBI rate of interest plus 2% becomes payable to all the allottees whom you have not given possession with occupation certificate. So no fit outs, there is no concept of fit outs, and no personal understanding with anybody, and nobody is going to leave you, even if he is your best friend, moment he knows that he is entitled to interest. So he is not going to leave you. Understand, we take construction loan of hardly 15 to 20% of the total project, and interest payment of interest on that kills us. And 90% of the projects have become unviable because of the loan interest which we are paying. Now you understand that if you have to pay interest on the every sales which you have made, every penny of the sales which you have received, including land cost and your profit, and you have to pay interest every month on that, it will be completely wiping out the balance sheets. So date of completion, don't over enthusiasm. Don't think, because there is no exception mentioned in the act which says that if the permission was not made available to you, you are entitled to extension of date or no interest is payable. only extension is possible is possible of the time is court stay, which is the stay period of the court stay, or earthquake, flood, and all those things. That's it. So please don't overestimate date of completion. Rather underestimate to an extent which is, feasible, where it does not stop your sales also simultaneously, but where it does not amount to actually paying out the interest on the money is received by you till the date of completion mentioned in the agreement. Mind well, there are you can have a different date of completion, and this you must understand. Registration is very simple, like he said, you will get in 5 days. But extension of registration of a project is next to impossible. Please bear this in mind. So the date of completion which you write in a registration site has to be sufficiently long so that you never have to go for extension of registration. Now that date of completion need not be same as what you write in your agreement. Your agreement of sale can contain a different date of completion which is below the date of, means suppose in registration project you have said that I will complete phase A of my project on 31st December 2021. Your agreement can write completion date as 31st December 2020. Your agreement can write that. Point is, if you don't complete the work by 2020 and give possession by 3020, your interest starts irrespective of what you have mentioned in the registration. Registration you might have mentioned 22, 24. And another issue is, suppose you wrote 31st December 2020 as the date of completion of the project on a registration and you are not able to complete, extension is next to impossible, because extension can be given only for 1 year thereafter. And thereafter the project will become unregistered, you will not be allowed to sell. You please understand, so the date of completion being mentioned in the registration has to be sufficiently long enough, so much long enough that all permissions, approvals, your experience, you know that Subodh Kumars will come and you will have no permission for 2 years. You know this. Your past experience tells you this. So please build in Subodh Kumars in your date of completions with agreement or in registration. Because if you don't do this, you are in trouble. The balance sheets will wipe out. So if you are advising owners or you are yourself owner, please keep this in mind. The date of completion is the fulcrum on which all penalties, all liabilities, all what is connected in the RERA, all penal provisions get attracted only from the one event. Till that time, RERA is only about disclosure. So make true disclosure, no issues. But the penal provisions start playing in from the date of completion. Date of completion mentioned in project registration and date of mentioned in the agreement with the allottee. These are the two things. Registration, you will land up into soup because extension is next to impossible, and in agreement, because interest nobody can waive. Compensation, and one more thing, from the date of completion, proposed completion which you have mentioned in the agreement, not only you pay interest 100%, there is no choice, but then the party can go for adjudication for compensation for the losses which is incurring because you have not given possession on the date mentioned in the agreement. So it is beyond interest, there is a compensation also. And that is to be decided by adjudication officer, where compensation can be about anything. About his loss of accommodation, temporary accommodation, his interest which he has paid to bank for last 10 years, whatever it is. So adjudication is a process which will commence moment the date of completion mentioned in the agreement is not achieved. So please, for God's sake, every promoter, if you are planning to complete a building in 3 years, you must write completion date in your agreement at least 5 years. This is my personal advice to everybody. That please, because you might end up into a big problem, and registration, in the time of registration, for that phase you should write completion as 7 years. Because it doesn't matter what you have written in registration, as long as your agreement says what you are going to do it. But registration, writing 3 years and getting only 1 year extension, for whatever reasons, approvals or whatever it is not going to happen. And timeline for refund, unfortunately, if he decides that if you have not completed in time and the market has tanked, and he decides to walk out of your project, in 30 days you have to make the payment to him with interest. In 30 days. So it is very important that the fulcrum of the whole act is date of completion mentioned in the agreement and date of completion mentioned in registration. Be careful, don't overestimate yourself. It is better not to sell flats today and better to do 2 projects less than to get into a commitment situation which can really wipe off the all 10 years or 50 years of earning. Disclosure on the website of the authorities. So authorities will have a web page of you, and on those website, all this registration granted by the authority, all this what I have talked earlier in earlier slides will be disclosed on the website of the authority as per the regulation which has been published by the authority yesterday. All this information will be published on the website. And beyond that is, you have to now quarterly update. What do you all have to update? List of number of type of apartments booked in this quarter. So gone are the days that this information is not available. So everybody will know what flats, how many flats we have sold in this quarter. List of garages booked. Garages includes covered parking. Quarterly update of the list of approvals taken. So in last quarter, what approvals you have taken? So incremental approvals which you go on taking, this also has to be uploaded every quarter. And quarterly update on the status of the project, that is percentage completed, all those things, and such other information which the regulation may come out from this. I don't know what more they want from us except at what time you go to bed and what time you get up. But this is all what these regulations can really talk about. Possession, provision relating to possession, like I said, possession are to be handed over on the date mentioned in the agreement. In case of delay, allot is entitled to interest, compensation, and at the time of possession now, you have to give necessary documents and the plans of common area and apartment of the building. So plans of the common area also to be handed over at the time of possession. The allotee should know about it. What are the common areas which you are going to give? So again, this is not in air. Any addition, alteration and modification only with the consent of the allotee. So here the importance of which I was about to tell you was of the phase. Am I overrunning the time? Fine. There is a phase. You please decide the phase, because your 70% money which is used in a separate account will get released on receiving occupation certificate of that phase. So if you are going, if you declare that you will be doing 6 buildings in a phase, then unless you obtain the occupation of all 6 buildings, you will not be able to withdraw the amount which is lying in 70%, which is beyond the construction cost or project cost which is allowed to be withdrawn. So it is important that you define the phase as per your progress which you are likely to achieve and sales which you are likely to achieve. So please, phase of the, and why? Because you are going to register the phase. Any addition, alteration and modification of the registered phase where any allotee is there cannot be changed without his consent. So in a layout, suppose I have done 7 phases, 7 buildings, each building is 1 phase, and I have registered 6 phases, but I have sold only in 1 phase. So whatever changes I want to do in that phase, I need consent of the allottees. But for the remaining 6 phases, I need not have the consent of the allotee whom I have given in the first phase, if I have separate phase. But I have registered all 6 phases as 1 phase, then any change which you want to do will require 2/3 consent of the allottees of that phase. So it's very important that how you define phase, how do you define the completion date, and how you work on that. And what are the modification, what are the definition of modification? If you read it, it's completely mind-blowing. Structural change including addition to area or change in the height or removal of a part of a building or any change to the structure, such as construction or removal or cutting into any wall or a part of a wall, partition, column, beam, joist, floor, including mezzanine floor or other support, or a change to a closing to any required means of access, egress or access, or change to fixtures and equipment is also considered addition, alteration. Please understand, they've left nothing under the sun balance. So this is how you have to sell. So you have to understand that you cannot now sell anything which is half cooked. It has to be, recipe has to be known from day one. The finished product has to be known from day one, and exactly the process of achieving recipe to finished product has to be known in detail, well planned, chalked out, and then decided. Defects liability, 5 years. So any allottee can, in 5 years, can bring out defect liability for structural workmanship or workmanship. Any workmanship, quality, provision of service, or any other obligation as per the agreement for sales within a period of 5 years. So the defect liability is within a period of 5 years. Now these are my duties as a promoter, what I am supposed to do. Besides all what I am supposed to load and all those things, defect liability for 5 years, obtain completion certificate, obtain lease or conveyance, and be responsible for providing and maintaining essential services. So all these are my duties. Now providing essential services are also part of my duties. So this is what it is. I have to also, it is my part of my duty to enable formation of legal entity. So it is no longer now left to the buyers. It is my duty that I must create legal entity and formation of apex body in case of a layout, and execute conveyance. Again, it is a part of my duty to execute conveyance for structure in case of a layout, for each building, and of the land in case of a two apex body. This is a very beautiful concept which has been RERA has brought in. In a layout, you can actually convey now structure, only structure to the society, and the entire land will be conveyed only to the apex body when the last of the occupation certificate of the last of the building proposed in the layout is constructed. So there will be no land conveyance which is happening in a layout till completion of the last building. But the structure of every building which you are constructing has to be, society has to be formed and has to be done. Society has to be formed as soon as 51% of the purchasers have purchased the flat. In the allottees have purchased the flat, the society has to be formed by you. So moment you reach 51% of the allottees, which you have, suppose you had proposed 100 flats, moment you have sold 51 flats, the society will have to be formed, and you have to also execute the conveyance of the structure in favor of society on receipt of occupation certificate, or 51% of the people who have paid entire money to you. If suppose you collect 100% money from 51% people, then conveyance has to happen of the structure, irrespective of whether the building is completed or not. So the way out is that don't collect last 5% till occupation is obtained. So this is how it is. And we have to pay all outgoings till you hand over the things to society, which by law now you have to actually hand over to the society within 2 months of the occupation certificate. It has to be handed over. Impact on ongoing projects, its disclosures of the ongoing project, extent of development carried out till date, last approved sanction plan of the extent of development of common areas and amenities done till date, expected period of completion, actual proposed date of completion which you had given in your various agreement, the reason for delay why it could not be completed at that date, and now expected date of completion which you are proposing. All these three things on the case of ongoing project we have to given, and a certificate from a practicing project architect certifying the percentage of the work completed on case of ongoing project has to be certified. So all these things has to be given. Then certificate from an engineer of the estimated cost of the project to be completed in case of ongoing also, in case of new project also. You have to give the certificate from the engineer of the cost of estimated completion of the project, and a chartered accountant which certifies that this is the total project cost, this is the balance, and this is receivable from the already sold stock, and what is balance unsold stock has to be multiplied by ASR rate of that area, calculated, estimated the balance sales recovery. Why this is important for ongoing project? Because if your estimated cost is higher than your estimated recovery, then 100% of the recovery from that ongoing project will go in a separate account, not 70%. So if your estimated cost to complete the balance project is higher than the estimated recovery, then 100% will go. If it is lower, then 70% will go. Mind well, don't fudge your estimated cost figure, because the money which you will be allowed to withdraw from the separate account is least of actual cost or estimated cost which you have given. So if you think that आज 30% निकालने के लिए मेरा बैलेंस कंस्ट्रक्शन कॉस्ट 1000 रुपया है और 700 रुपया मैं आज लिख देता हूँ so that I can 30% में निकाल लूँ, So my actual cost will go on going, but my withdrawal will be allowed from the separate account, which is proportionate to 70 rupees. So moment you try to fudge estimated cost, your withdrawal will get affected. Moment you fudge estimated cost to get lesser penalty, because your penalties are 5% and 10% of project cost, but your withdrawal starts getting restricted, you will not be able to deliver the project. So it is very important to be truth in whatever you do. Rights of the developer, what rights I have finally after so many things. So I have decide what is a phase of my project. What is date of completion of each of the phase and real estate project as a whole. Completion date of services. Claim interest from LOT if he defaults for default, and cancel the agreement only if he makes 3 defaults in the payment. These are the only rights I have besides whatever right I may imagine I have. Separate account. Separate account cannot be the escrow account of the bank or the lender account. It has to be over and above that, and from there the monies will be withdrawn for the purpose of certificates. There are 3 certificates to be taken, and there are well-defined areas which each person has to give. Architect has to give what, engineer has to give what, and chartered accountant has to give what. That certificates are uploaded on the website. Land cost includes cost of TDR, premium, removing encumbrances, stamp duty, rehabilitation cost in case of rehabilitation project, and interest cost. Construction cost includes offshore and onshore site expenses, taxes levied on construction, principal amount on interest to the financial institution on construction loan. These are the various formats. I wanted to go in details of the architect, engineers, and chartered accountant certificate, but I think I don't have a time. I'm engrossing upon Suhas's time. So thank you very much, but these are the formats which are available on a regulation. Well-defined, separate rules. Architect will not certify what engineer has to certify. Combining architects and engineer certificate, chartered accountant will be able to certify easily what we can withdraw as an amount from that. Even in engineer's certificate, there is a provision made for our estimated cost for items which are not imagined at the time of giving estimate, extra items which we have to do. So all this has been there. There are all formats which are there on the website. Thank you very much. This was wonderful. Thank you.